Lachowski i Piątkowski o prawie międzynarodowym. Podcast Wydziału Prawa i Administracji Uniwersytetu Łódzkiego oraz portalu Obserwator Międzynarodowy.
Good morning, our English-speaking guests. Let me first turn to our Polish audience. Dzień dobry, szanowni państwo. Przywitanie dość nietypowe, ale mamy ku temu szczególną okoliczność. Mam przyjemność zapowiedzieć kolejny z naszych materiałów wideo. Tym razem jest to nagranie specjalnego panelu, który odbył się podczas konferencji organizowanej przez Wydział Prawa i Administracji Uniwersytetu Łódzkiego, profesor Joannę Połatyńską, profesor Łukasza Korporowicza, konferencji, która miała miejsce w dniach 16-17 maja 2024 roku pod tytułem International Law, Its Heritage as a Response to Modern Problems. Konferencja ta zgromadziła wielu ekspertów z zakresu prawa międzynarodowego. My natomiast nagraliśmy specjalny panel poświęcony zagadnieniom tak zwanego prawa antyimperialnego, zagadnieniom postkolonializmu, zagadnieniom relacji globalnego południa oraz naszego regionu, także z uwzględnieniem aktualnej sytuacji w strefie Gazy i Ukrainie. Naszymi gośćmi była pani profesor Patrycja Grzebyk z Uniwersytetu Warszawskiego, pan dr Patryk Labuda z Polskiej Akademii Nauk oraz profesor Marek Wasiński. Dziękujemy za wysłuchanie naszej audycji w języku angielskim. Dear English-speaking guests, hello and thank you for tuning to our podcast about international law. I am Mateusz Piątkowski, and together with Dr. Tomasz Lachowski, we are co-hosts of podcast about international law named Lachowski and Piątkowski o prawie międzynarodowym. We are both representing University of Lodz, Faculty of Law Administration, Poland, and we would like warmly invite you to listen to our recording that took place on 17 May 2024 during the International Scientific Conference titled International Law, Its Heritage as a Response to the Modern Problems. During our recording, we talk about three prominent experts, representatives of the Polish scholarships, about Counter-Hegemonic Approach to International Law by Global Southeastern Europe between Ukraine and Gaza Strip. Our guests were Professor Patrycja Grzebyk from University of Warsaw, Dr. Patryk Labuda from Polish Academy of Science, and Professor Marek Wasiński from University of Lodz. Thank you very much for choosing our podcast.
Okay, so let's start our afternoon session today. We will try to tackle the most contemporary issues of international law and international relations with great speakers. I would like to welcome Professor Patrycja Grzebyk from University of Warsaw. Also Dr. Patryk Labuda, Polish Academy of Sciences, Institute of Law Science. Welcome, and Professor Marek Wasiński, Faculty of Law Administration, University of Lodz. Today we have decided with my colleague Mateusz Piątkowski, who is also the co-organizer of this special panel, to title this discussion Counter-Hegemonic Approach to International Law by Global South and Global Eastern Europe between Ukraine and Gaza Strip. Those two events that we are observing in the last months, but also, of course, years, in case of the Russian aggression against Ukraine that lasts more than 10 years in 2024, and the Gaza Strip armed conflict, more than half a year still ongoing, are the fundamental questions related to the global response to the issues of the security and peace and security of international global affairs. We will divide this discussion into four rounds. The first In first round, I will ask the same question to all our panelists, who will have 5 minutes to respond. Round one is named Post-Colonial Studies. What does it mean? And actually, post-colonial studies are now a trending subject, especially the critical approaches to international law, not this mainstream education that, especially in the Western world, also in Poland, we are now experiencing. And the question is, how do the scholars, and particularly you in personal, understand the geographic scope of the phrase post-colonial studies? The conventional wisdom is associating this term with the European domination and colonization and expansion in Africa, Asia, South America between the 15th and 19th century. Would you advocate that the Central Eastern Europe is also a zone of this kind of forgotten colonialism, and shall be actually also covered by this discourse of post-colonial studies, not just legal studies, but post-colonial studies? Professor Patrycja Grzebyk, you have a privilege to start our discussion.
Thank you, and also I'm very grateful for the invitation to Łódź and also to see so many familiar faces to me, my friends from international law world. Answering your question, I think that we need to stress a few things. If we talk about these post-colonial studies and the issue of the colonial domination, it did appear in international law for decades. And I would, for example, from my perspective, I'm dealing with international humanitarian law. I do remember the whole discussions which is around the adoption of additional protocols to Geneva Conventions of 1949. Those protocols were adopted in 1977, and in first additional protocol, they managed to broaden the concept of international armed conflict to encompass also the fightings against colonial domination. And at that time, it was quite clear that when we talk about colonial domination and to address colonial problems, we are talking about those states which were addressed in relevant resolutions of the General Assembly from 1960, 1965. So as you just explained, those territories which were under colonial domination, which were considered as trustees, as mandates, but not necessarily our part of the world. And this is understood because at that time, when those treaties were adopted, we were in Eastern Bloc. We were promoting the new approach to post-colonial states, but we could not present ourselves as victims of the colonial policy. This just appeared after 90s, and I do remind you, for example, the conflict in Chechnya, where, for example, Chechens tried to argue that their conflict, their fighting for independence, is a kind of struggle with colonial force, which was Russia as continuator of USSR. And today we also try to find a direct link with the post-colonial states and to explain them that we cannot be perceived as the part of the West, that we have a separate history, and that we also suffered from some subjugation, some occupation. Although I think that we need to keep the proportions, that we need to make a distinction between the states which were exploited, which were, the people massacred in the mass, just to remind you the situation in Belgian Congo, but at the same time to stress that for many decades we were not independent, we could not decide about with our sovereign decisions, and that's why we can have a lot of empathy towards those states which are considered as traditionally colonial ones. And also, what we can consider, we know that there were some treaties adopted in 60s, 70s with specific examples in the head. However, those treaties are vivid instruments, and maybe those expressions which were used at that time should be reinterpreted in the light of the current events. And we can try to do it, although I think with a huge respect for those traditional colonial states, to not hurt their feelings, to not hurt their feeling of being victim for decades or centuries in some cases.
Thank you so much. Patryk, post-colonial studies, what does this term mean to you personally as a scholar dealing with this topic in your daily research activities?
Thank you. So I think I'm going to repeat a little bit what I said earlier today, because we already had a conversation in one of the panels. And I think there are two ways of thinking about this, right? Taking a step back. The traditional way of thinking about post-colonialism is to think of Western colonialism, Western European colonialism, and its assumptions, and then applying that to sort of generate epistemological insights that range from politics to sociology to law, international law. And then there's a different way to think about this, which is to sort of dissociate the label from the Western experience and go to the heart of the substance of colonialism. What is substantively colonialism? And then trying to figure out if we can find parallels in other parts of the world. So similar experiences of exploitation, domination that happened not only where the Western empires operated, but also in other contexts. Now, I personally don't have a problem with this second way of thinking about colonialism or post-colonial studies, but I do think we need to be aware of certain risks associated with this approach. One of which Patrycja already alluded to, which is the sensitivities around the term colonialism. There are certainly, I think, populations in the global south in particular that will not necessarily find this understandable at first. And so I think we need to be aware of these sensitivities and engage with this in a very thoughtful manner. I think then another risk is that we need to avoid this becoming a form of victimhood Olympics. Who has suffered the most, right? Is it peoples in Asia or peoples in Africa or in Eastern Europe, where we're just trying to figure out who has the greatest claim to victimhood? I think that is a certain risk also, and it's something that we need to engage with thoughtfully. And I think the last point that I'll make is I think we might want to, going forward, think about the way in which post-colonialism can be understood both as an advocacy strategy and a scientific endeavor. And I think it might be useful to keep those two approaches in mind, because I think what we see, for example, in Ukraine is that the word colonialism, post-colonialism, is oftentimes used, I think, as an advocacy strategy. So Ukrainians in particular are trying to draw parallels between their experience and the experience of other peoples who suffered exploitation, but without necessarily engaging with the scientific dimension of colonialism and post-colonialism. And I'm sometimes ambivalent about that approach. I think we need to be mindful of the different ways in which the terms are used, and especially as lawyers, we try to define things. So again, I would try to keep that in mind.
Thank you so much, Marek. Post-colonial studies. I know that you conduct the research on the Central and Eastern Europe as a post-imperial zone. Does it mean that you look at this space through the lens of post-colonial studies?
Yeah, thank you very much for this question. And well, at the beginning, when I try to answer your question, I would like to refer to what Patryk said. Namely, there are many ways we can use this discussion about post-colonialism. We can use this discussion as a tool for advocacy. But for me, and I want to highlight this very, very strongly, this is all about self-reflection. Self-reflection in particular about the way we perceive international law, we practice international law. And Tomek distinguished between two terms: coloniality, post-coloniality, and imperialism and post-imperialism. This is very important to me. And let me start with a personal example, an experience. Whenever I have classes on TWAIL, or whenever I have a general course on international law and we discuss the problem of statehood with the students, we come across several authors from the beginning of the 20th century. James Lorimer, for instance, Pasquale Fiore, and they distinguished between civilized communities governed by international law, barbarian communities, well, semi-periphery, let's say so. So I mean, Turkey, China, Japan, and well, savage communities beyond perimeter of colonized, of civilized world, beyond perimeter of international law. And then the next step is that we read together a very short snippet from a diary published in 1774, so roughly 7 generations before my birthday, not so long ago. This is a diary by a traveler, Gough Foster. And this is a very short snippet, a description of a land which is gloomy, dilapidated, inhabited, and this is direct quote, inhabited by people half white, half civilized, unquote. And obviously I ask my students, can they figure out what is the land so described? And you know, 95% of answers, of guesses, this is Central Africa, Congo Basin, or Central Amazonia, or the Pacific Island. But as you can expect, this is not of the sort. This is Central Europe. This is Northern Poland, Pomerania region, so close to the Baltic Sea. And the next step is the discussion whether the students perceive the Central and Eastern Europe as a post-colonial space. And in most cases, they are reluctant to admit that we share the same kind of experience with peoples of Africa, peoples of Asia, who were subjected to colonial domination in the past. So the conclusion is that, well, quoting Wittgenstein, the meaning of a symbol is not in a definition. The meaning of a symbol is in the use. So that's why I would be reluctant. I would avoid the phrase, well, Eastern Central Europe as a post-colonial space. I would rather skip towards or veer towards this post-imperiality. And why I think that people living here share experience of a post-imperial space. So let me quote French ideologist of imperialism, early 20th century. His name was Jules Armand. Okay. And Jules Armand directly stated that races are not equal. Races are not equal, and behind every attempt of imperial conquest, there is ideology and there is a feeling of superiority. And this, according to Armand, conquest is not justified by the feeling of economic superiority, political superiority, by a feeling of moral superiority. And just to conclude, I think about all those generations of people living on this land who were subjected to conquest, to domination, that was driven by the, well, idea of moral superiority. How this can affect the way we, right now, myself, how I perceive international law, the practice of international law, the training in international law. So, to conclude, I think that it is, well, a good starting point for self-reflection about this. Thank you.
Thank you very much. Thank you for the round one. And let me move to round 2 of our discussion, which is titled Global South and Global East, Different Approaches to International Law, which of course will continue those deliberations that our great panelists started in the first round of our discussion. This time I will start with Professor Wasiński. You mentioned just a minute ago the way of thinking of international law in the Global South, this twelve approach to international law, which also is changing throughout the time. There are different stages, different phases of understanding international law by thinkers, by legal scholars, but also by intellectuals in the Global South. And having in mind the legal discourse or the scientific discourse on the topic, do you see any kind of reflection in the third world or in the Global South having this today's name or a label on the Central and Eastern Europe? Is our region actually being researched by the 12 scholars, and how do they perceive our region, especially in the context of the Russian aggression against Ukraine or the situation in Gaza Strip, which also corresponds to this global response towards the main problems of security? So 12 scholars, 12 thinking, how do they perceive Central and Eastern Europe? 6 minutes.
Okay, so assuming that we stick to 12, leaving outside the scope of our consideration other trends of post-colonial studies, my answer is simple: no. But let me substantiate my position. Just two examples again. A few months ago, I contacted my academic collaborator who is affiliated with university in the Global South. I asked him to assist me in organizing an event, a kind of workshop or seminar, just for discussing the problem of the Eastern and Central Europe as a post-colonial space. And the feedback was generally very positive. Well, you just come and then we will organize something, but there was one warning, namely, please avoid, and I repeat what I have said before, avoid the term post-coloniality in reference to this part of Europe, because this could be perceived as inappropriate appropriation of certain symbol, cultural symbol. So this is one example. And the second example, the scholarship of Twale, if we stick to this brand, is well developed. So let me pick up only one name: Edward Said. Edward Said, a forerunner of post-colonial studies in general, the author of famous Orientalism. But his second book was Culture and Empire, if I am correct, or Culture and Imperialism. And there is a significant thing that this book is opened by a quote from Joseph Conrad. Joseph Conrad, this is about the relationship between imperialism and culture. Just before this seminar, before this meeting, I opened Encyclopedia Britannica to find out more about Joseph Conrad, and the entry begins with Joseph Conrad, British novelist, British writer of Polish descent, born in Berdychev, Ukraine, and listen carefully, Russian Empire. And the snippet from Joseph Conrad opens this great book by Edward Said, 400 pages long, discourse, study about relationship between empire and colonialism. And believe me, in all this, in the entire book, you will find some 8 passing references to Soviet Empire, and equal number of passing references to the Russian Empire. Isn't it striking? There is a clear omission, and Well, so that's why my short answer to your question was no. But if I have one additional minute, let me say something more. Why do I think that we can and we should treat Eastern and Central Europe as a post-imperial space? And another reference, this time to one Swiss historian. His name was Gonzague de Reynaud, and he stated quite clearly, European nations are not equal. We should distinguish between the Western Europe and the rest, right? And important thing, he said that the Western Europe is the European Europe. Western Europe is the European Europe which invented international law, the European civilization in general. And, well, the final point is that this indicates that we should not put all parts of Europe in the same box when we talk about history of the civilization in the 19th, 20th century. We should distinguish, and we should take into account the experience that we highlight, the experience, personal experience of people living here. Thank you.
Thank you so much, Marek. Marek has just explained the main paths of thinking of third world approaches to international law. And now I would like to pass the floor to Professor Patrycja Grzebyk, trying to ask for the approach which is observed or might be observed in our region. Actually, can we say that Central and Eastern Europe has developed its own understanding of international law, especially taking into consideration our legacy, the very tragic legacy of two totalitarian regimes that had invaded Poland in the Second World War, with a huge number of war crimes, genocide, crimes against humanity. Can we say that actually there is something like the Central and Eastern European approach to international law, and what is the place of Poland, actually, in Polish legal studies in this subject? Also 6 minutes, please.
Well, this is not an easy question, because first we would struggle with definitions, because my colleague just asked me about the Central Eastern approach, and then I have a problem, because if we talk about Central Eastern Europe, this would be not only Poland, not only Czechia, but for example also Germany, Austria, Croatia. If we would go to the division which we have within the United Nations, we would rather find ourselves in Eastern European group, where you will also find various states, including Albania, Bosnia and Herzegovina, but also Russia, Georgia, so really quite various and distinct states. So the issue is that we cannot even decide about what kind of group we need to talk. Central Eastern, Eastern Europe, how far is this East? Because you also use this global East perspective, and so together with China, together with Asia, do we have something common? But I think that what we can deduct also from the comments before, there are some states which have very common history, very common legacy in this post-imperial world. And these are the states which were affected by the imperialism of Nazi Germany and then of Russia, USSR. And how this impacted us? Of course, that we could say that because of the war conducted by those states, we were not independent. We could not have an independent foreign policy. But at the same time, we can see that we had this tragic experience, and no matter whom you were supported, whether you were communist or you were not communist, there was some common interest, common values shared by everyone. And for example, this interest was that we know that civilian population is suffering the most during the armed conflict, that the issue of prosecution of international criminals is quite crucial for us, that we see the advantage in development of human rights. And of course, today we are tempted to criticize everything which was proposed during this period between 1945 and 1989. But we cannot neglect the fact that at that time we had some limited freedom to propose some issues which were considered as not harmful to the interests of USSR. And this was, for example, these states, these Eastern European states, which were promoting development of international humanitarian law, promoting development of international criminal law, which were believing that for us, not the power, but the law could be the solution of our problems. And those states were really engaged in developing those instruments. Of course, they were also engaged in political speeches, in criticism, which we could hear also from the Soviet delegates. But at the same time, they did truly engage in development of these humanitarian aspects of law and this humanitarianization of international law. And this is something which is much forgotten now, and even forgotten by our own states. And we could observe, like, we forgot about those values when we finally could ally ourselves with the West, and we committed our own sins together with the West and forgotten about this legacy. And Tomek, I would also refer to your words at the very beginning when you said that, okay, now we observe for a few years the conflict between Russia and Ukraine, but also your panel is about Gaza, and Gaza, it's not only the last half the year, these are the decades. And if you look at those decades, you could see that, for example, Poland and many other states from our region, they did support, on the one side, statehood of Israel, but on the other side, also self-determination of Palestinian people. And this was from the very beginning. Also, I do remember that, for example, recently our Minister of Foreign Affairs did remind that Poland recognizes statehood of Palestine since 1980s, which could be quite surprising to some of us. However, this shows that even with this tragic legacy, with this tragic experience, and also remembering that some of our states from our region were not among allied states. They were also allied to Nazi state, but still they suffered from World War II. And for example, just think about Yugoslavia, who at first was with the Axis, and then the all losses changed the ally, and also the losses were tremendous in this region. And this really had a huge impact on the way of thinking, on the way of argumentation of those states on international level.
Thank you so much. Trying to combine those two perspectives of global South, the understanding of international law, and Central and Eastern European perception of international legal system, I would like to ask Dr. Patryk Labuda the question concerning the possible establishment of the special tribunal on the crime of aggression against Ukraine. One of the biggest legal challenges that is rooted in the Russian invasion of Ukraine is the question of the accountability of leaders of the Russian Federation, the decision makers who made the decision to invade a sovereign country, sovereign Ukraine. And the question is, how do you think Global South countries, Global South politicians, intellectuals, scholars, should they support actually the idea to create a special tribunal? Because if we look at the discussions nowadays, more or less the core group, which is very deep into discussing the possible establishment, is more concentrated around the Western way of thinking. So what about the Global South approach to this idea to prosecute and punish the perpetrators of the crime of aggression against Ukraine? 6 minutes.
Thanks. Yeah. So I think partly the problem is the way in which the question is formulated. It assumes that there is something called the Global South. And I think, maybe let's take a step back. We all generalize. We talk about the West. We talk about East Central Europe. We talk about the Third World. And this is understandable to some extent. But then we do need to think a little bit harder about these categories. And why do I say this? I'm not going to try and define the Global South, but in the context of the discussion on the Special Tribunal for the Crime of Aggression, for those of you who are not familiar with this discussion, there is a proposal to prosecute the Russian leadership for the crime of aggression and to establish an ad hoc tribunal, a special tribunal that would deal just with the crime of aggression in Ukraine. The reason for this is that the International Criminal Court cannot prosecute that crime. The crime of aggression, currently, the way it's formulated in the Rome Statute of the ICC, does not allow the International Criminal Court prosecutor, Karim Khan, to initiate prosecutions of the crime of aggression. And therefore, we need an ad hoc tribunal. Now, this proposal has indeed received primarily support from European and North American countries, but there is much less support outside of Europe. Now, one narrative that has become very prominent in mainstream international law commentary on the tribunal is that there is a conflict between the Global South and the West, and it has to do with Western double standards. The reason the Global South does not support Ukraine's quest for accountability is because the tribunal is an example of hypocrisy, double standards in international law, and therefore the Global South objects to these double standards. In my scholarship, I've tried to reformulate this question, and I'm drawing attention to Eastern Europe, the experience of Eastern Europe, to argue that, on the contrary, prosecuting Russia for its invasion of Ukraine is not a double standard. It is dealing with a serious problem of post-colonial. I use just for those of you who did not notice this, there is a slight, maybe not disagreement, but I think we think differently a little bit about labels, Marek and I. I'm less opposed to the post-colonial label in East Central Europe. I'm not sure that post-imperialism solves the problems that we need it to solve, but it's one that's up for discussion. I think this is why it's interesting. I mean, it's an emerging debate among scholars from this region. But just to come back to my initial thought, so I think that prosecuting the crime of aggression through the special tribunal for the crime of aggression against Ukraine does not amplify double standards in international criminal law. On the contrary, it decreases double standards. It decreases post-colonial impunity, in this case in Eastern Europe. Centuries of Russian imperialism, Russian colonialism, if you will, and therefore it has immense emancipatory potential for international law. And I find the idea of Western double standards as sort of the main frame, the main lens through which we analyze this proposal for a special tribunal, very problematic and very West-centric in nature. It really makes the West the center of the world, and we always have to go back to the West's behavior as sort of the benchmark for evaluating the legitimacy of international, in this case, international institutions such as the Special Tribunal for the Crime of Aggression against Ukraine. And my argument is, on the contrary, let's take a closer look at what Global South states think about the crime of aggression. And if we try and really unpack that term, Global South, we realize that it's a lot more complicated than the Global South. I'm not sure that China's perspectives on the crime of aggression are the same as Malawi's perspectives on the crime of aggression. There are huge differences here between different regions, Latin America, Asia, Africa. There are regional hegemons in each region to some extent, especially in Asia, the Chinese experience, India. And the reason this tribunal can have emancipatory potential is not just because it matters for East Central Europe, for Ukraine, for other countries that have been invaded by Russia in the past. It matters for these smaller states in the Global South, in different parts of the Global South, that in the future may want to leverage this precedent and push for accountability for aggression in their backyard. I'm thinking here of the DRC's advocacy, the Democratic Republic of Congo, that continues to advocate for aggression prosecutions against Rwanda. I'm thinking here of the experience of Western Sahara, for example, in North Africa. So the precedent matters, I think, a great deal, not just for our region, it matters for other spaces where imperialism and colonialism in the past have contributed to, an unjust global order. So I think I've run out of time. I wanted to say one other thing, but I think I'll stop there and we can come back to it if there are questions. Thanks.
Thanks. We have concluded round 2 of our discussion. Let's move to round 3, which is devoted to current challenges of international relations, analyzed through the lens of different attitudes towards international legal systems. Of course, we are trying to go deeper into the topic. In order to comply with the principle of equality, this time Patryk Labuda will start the third round of our deliberations. You have mentioned the International Criminal Court, which is not able of dealing with the crime of aggression. However, in terms of Ukraine and the Russian invasion, however, the ICC is involved in the Ukrainian situation alongside the situation observed in Gaza, in the state of Palestine. Very often, the ICC is labeled as a neo-colonial tool of the West. However, when we try to assess the last months of the use of the ICC, you can see that, especially in terms of the Gaza Strip situation, 5 countries coming from this very vague term of Global South, however, they come from not Western world, activated, they referred to the ICC to prosecute the Israeli troops and decision makers. Do you see that the ICC is in a very crucial moment for its future? How do you perceive the situation and the International Criminal Court as a potentially very effective or very weak institution?
So the last part of the question is, it's a crucial moment for the ICC, and is it a strong or a weak institution? So, I mean, I'm blanking a little bit because I received a different question to prepare, so I'm trying to think how to respond to your question. I mean, I think it is a very crucial moment for the ICC, and how it responds to the challenge in Gaza will define, I think, its legitimacy. So maybe I'll take a step back and just think a little bit about some of the criticisms that have been leveled at the International Criminal Court for the past 15 years. And of course, the ICC has been accused of many things, of neo-colonialism on the African continent. It's been denounced for its selective prosecutions there. And I mean, I've always approached this with a bit of ambivalence. I think, the rhetoric of neo-colonialism that's been thrown around to delegitimize the operations of the ICC is fragmentary. It doesn't provide us with the full picture, and I think we need to be careful. We need to be careful in using these terms to delegitimize the ICC. At the same time, I think it's perfectly fair to interrogate the fairness of the ICC's prosecutions, where it investigates, where it prosecutes, who it investigates, who it prosecutes. And of course, there has been sort of an imbalance. There has been an imbalance in the focus of the International Criminal Court, primarily on the African continent in the first 15, 20 years of the institution. And now the question is whether the ICC, the prosecutor Karim Khan, has managed to pivot away from Africa. And of course, the Ukraine investigation, when it started, it was perceived as a moment of opportunity, that finally we are rebalancing the scales of justice, that now the ICC is not focusing only on the African continent, but very quickly the same kinds of critiques came back, that actually now supposedly the ICC is favoring Europeans over Africans, over people of color from other continents. And again, different kinds of critiques, different geopolitical contexts, but essentially it was the critique has come back that the ICC is not a fair actor. It is not prosecuting equitably across around the world. And of course, this brings us to Gaza, and of course the decisions of the prosecutor now in Gaza with respect to crimes allegedly committed by both Hamas and Israel. And I do think that we are at a very important moment when one observes how people talk about international law in general, but also the International Criminal Court in particular. I do think that there is a sense that how the ICC acquits itself of the task that stands before it will determine the legitimacy of the court, the legitimacy of international law and of international institutions more generally. My sense is that we should wait and see. We should give the prosecutor a chance. I have my concerns about the way in which the ICC is proceeding in Israel and Palestine right now. My concerns relate not so much to the ongoing hostilities post-October 7th, because I feel that there we can still give the ICC the benefit of the doubt and say it's only been 6 or 7 months. Maybe the prosecutor is struggling to collect enough evidence to bring cases. So I think, you know, for people who really study the International Criminal Court, we know that these things are complicated. Bringing cases, finding the evidence is complicated. So I would give the prosecutor the benefit of the doubt with respect to post-October 7th events. Where I'm a little more concerned is the West Bank. I mean, this is not a new situation. The settlements in the West Bank that are illegal under international law, there's no two ways to interpret the facts there, and the law. The law is very clear that occupation, illegal settlements are a war crime under the Rome Statute, and the fact that the ICC has not moved ahead with its investigation and prosecution there gives me pause. I do feel that the critiques that are coming are legitimate. They're fully legitimate, and I do understand why many people are concerned about potential selectivity in how the prosecutor is proceeding, and I do think that we should expect some kind of action there in the very near future, or else people will perceive this. I'm wrapping up. But yes, the people will perceive the International Criminal Court as a neo-colonial institution. I mean, I wouldn't use those terms, but certainly an institution that struggles to deal with the same allegations of crimes in different parts of the world in the same manner. Right? So selectivity remains, I think, the biggest problem that the ICC faces.
Thank you very much. Marek, being still in Gaza Strip, I would like to ask you about your perception on the Central and Eastern European response towards the situation in Gaza. Just after the 7th of October last year, the position was very clear that the Western countries and the Central and Eastern European countries are unquestionably supporting Israel. However, if we look, for instance, at the last voting in the UN General Assembly, as Patrycja has mentioned during her intervention, Poland actually voted for the support of the state of Palestine possibly becoming the UN member. So, what is your actually attitude towards the question on the possible response of our region towards the situation in Gaza? Of course, having in mind the international legal institutions.
Well, this is a really tricky and difficult question, because I feel that I'm expected to review or scrutinize to a certain extent the action of Polish government, and I wouldn't like to go that way, but let me avoid answering directly in an elegant way. So I would like to quote Marek Wasiński, who said that teachers of international law and students of international law should not pretend that they are decision makers, because we are not. We are not, and let's veer away from decision making. But instead, we should understand the decision-making process. So we should try to find out. We should make a map or a chart of possible decisions to understand some assumptions behind any possible decision, and to find out which assumption is better from this or that perspective. Well, so having that in mind. When I observe the position of the Polish government and the Polish president in respect of the conflict in the Gaza Strip, well, I think that this position is a default position for the Eastern and Central Europe, because this position is well balanced. What I mean, so when I read statements by the Polish president, I can find that he highlights the necessity to protect civilian population on both sides, both Palestinians and Israelis. This is very important. And secondly, the president also states that Poland, if I understand well, supports the idea of two states in the Palestine. So this is reasonable, well balanced, and well, nothing to add. But if you want me to be a bit more critical, well, I'm not sure if my criticism right now will be well positioned, but let's try. Let's take a look at the two proceedings pending before the ICJ right now, and let's compare these two cases. I mean, Ukraine versus Russia, I mean the second proceedings initiated in 2022, and the Republic of South Africa versus Israel. Both has one common denominator, namely the Genocide Convention behind. This is the substantive ground of both claims. And I compared the list of intervening states that use Article 63.2 of the ICJ statute, and discrepancy is striking. In the former proceedings, approximately 30 states intervened. Eastern and Central Europe is really well represented. Poland also submitted written statement, written position. And interestingly, I could not find any state intervening from the so-called the third world. On the other hand, when we see the case between South Africa and Israel, we have only 3 intervening states on different grounds, and they are Libya, Colombia, and Nicaragua, right? and I could not see any Eastern European state intervening. Well, perhaps there are political reasons, there are legal reasons, procedural reasons behind this decision, but if we want to be critical and if we want to exaggerate a bit and simplify, I have these statistics in mind when I think about Ukrainians dying since 2 years, when I think about Israelis and Palestinians dying, and forgive me the oversimplification, this may be rude, but they all die for a certain legal concept. I mean the right to self-determination. So from this perspective, their position is sort of equal. And the question is, well, why Eastern and Central European states decided not to intervene in the later case? Is it a kind of social Darwinism? I mean social Darwinism, I mean that, well, we are interested in the Ukraine-Russia case because this is so close, we are so exposed to physical extermination by the conflict in a neighboring state. But this is a kind of unsocial behavior, I would say. So I would consider seriously intervening in the second case. Thank you.
Thank you very much. Patrycja, let's imagine that in the near future the ICC would issue a warrant of arrest against the Israeli Prime Minister Benjamin Netanyahu. And even though today we think about this as a kind of legal or political fiction, let's remind the situation with Vladimir Putin. Just 1 year of the full-scale invasion, I think no one expected that the ICC, firstly the OTP, but the ICC would confirm the appeal of the prosecutor to issue those warrants of arrest against Vladimir Putin. So if it happens against Benjamin Netanyahu, what shall be the position of the Central and Eastern Europe in this question? Shall we as a region support trying to say that the international legal system is universal, and we shall support all endeavors that are dealing with international core crimes? Or maybe you have some other perception.
I'm tempted also to comment what just Professor Wasiński said, so I would also refer to your comments. But starting with Netanyahu, I wouldn't think that it is that there is no probability that he would be accused, because there's a huge now pressure, and of course the situation in the West Bank, because we remember about 7 October, but we forgot that, for example, 2023, the beginning of the 2023, this was the announcement of the biggest initiative to build additional settlements in the West Bank. Yes, so that's why we have this huge dispute: who started the first, who should be blamed more, and this victimhood Olympics about which you were talking, Patryk. I think we also have now a huge pressure on the ICC, and just today there was the statement made by the presidency of the Assembly of States Parties. In this presidency we have our Polish representatives. This is Ambassador Kazangama, who is vice president, and they stressed that we cannot accept attacks against impartiality, independence of the court. And in my opinion, I know that we need to also, I'm very grateful for your remark, Marek, that we also need to think about dissidents who need to take into account different interests. And we, for example, Poland, we are engaged, we support Ukraine in the war with Russia. And we need to take into account different interests. And we calculate whether to support one or another side would impact our situation. And we talk about enormous amount of global South states which support Palestine, but also we cannot neglect that one of the states which enormously support Ukraine is US, which supports Israel. So this is a very tough situation for us. And I think what is the safest For example, in case of Poland, and I'm talking just about Poland because we don't have one position of Central Eastern Europe. We have one position of Poland, which we can say that we are for better implementation of humanitarian law. But for example, we have Czechia, which supports extremely, to the extreme Israel, no matter what is going on. And I think that what is safe is to say, let's just have tribunal to do the job, which is not easy, having in mind that the tribunal works on the principle of complementarity and needs time to check whether the investigations are ongoing in various states. But I'm always concerned about those various engagement depending about what region we are talking about. Because in case of referral of the situation in Ukraine, we have those 40 referral, maybe from the Europe, but also like Japan, but also Costa Rica, but also Chile, for example. So we had, also representatives of the Global South. And we didn't have any referral from the North in situation of Palestine. We have only referral from South Africa, Bangladesh, Bolivia, Comoros, Djibouti, Chile, and Mexico. And I'm wondering why there is no such a referral, because it's quite safe. It's just to say, let's have ICC to deal with the situation, which would mean that they need to deal not only with the crimes committed in Gaza, but also with those indiscriminate attacks from Palestine to Israeli territory. So we say we don't take any sides, just check the situation because the crimes could be committed on both sides. And I'm really concerned about the situation in the ICJ, which you've just mentioned, and this, massive intervention in situation of Ukraine, but lack of interventions in other cases like South Africa versus Israel, but what I would like to notice that, for example, in Gambia versus Myanmar, you have the intervention of Western states. They were waiting on the merit base. And I need to stress that, for example, now we've just moved from, we are still at the jurisdiction level in South Africa versus Israel, and many interventions at this stage could be considered as premature. So I do not, I would expect some interventions more in the future. Especially that intervention based on Article 63 is quite, I would say, safe one, because you just refer to the construction of the convention. However, I would also refer to the ICJ, but in another aspect. Please have in mind that we have now advisory procedure concerning the situation of the Middle East with unprecedented number of written observations submitted. We are preparing, we had also the oral phase, and we had, over 100 statements made by states, by organizations, and you could see that you didn't have, Global South versus North or West, but I would say quite cautious statement by many states, having in mind the situations in different regions. And I think that this advisory procedure could be even more interesting than those genocide proceedings, which are very limited because they need to be limited with the extent and to what can be said based on the intervention based in Article 63. And we also mentioned hypocrisy. Patryk, you were referring to this. And I think that sometimes it's very easy to use this argument, but okay, let's just check, I don't remember any time when US was supporting the prosecution of aggression in general. However, Russia and USSR were famous because of their efforts to prosecute aggression. So that's why we need to say there were some mistakes in the past, but the time flies. We make improvements, and if you had some such champions of the prosecution of aggression, like Russia wanted to present themselves, let's now check it. Let's now check it against your own words and against the treaties which you have adopted. And I do refer to, for example, interworld treaties, the London Conventions proposed by Russia at that time.
Thank you very much. I think that our discussion so far has shown that international law that shall be universal in its roots and nature, of course, is understood in a very different ways, especially in those hotspots and very geopolitical context of the application of international law. And round four, my question, my request. Very humble for the summaries of your interventions today, trying to especially take into account this notion of universality. Maybe we should just accept that international law in de facto manner is not universal, and we have to take into account this approach. I always refer to the same example in such a discussion of the voting in the UN General Assembly of 2nd of March 2022 under the formula of Uniting for Peace, when 141 states voted for naming the Russian conduct as an act of aggression. So in the ideal world, at least up to my mind, those 141 states shall also advocate, shall also promote and support the immediate withdrawing of Russian troops from the internationally recognized Ukrainian territory, shall support the punishment of the decision makers who committed the crime of aggression, and to support the reparation for all suffering and damages. However, if we go into details, also we can say that just the Western countries are supporting to some extent the special tribunal or the reparation program. So what is your final opinion about international law through the lens of the question of universality, having in mind those two examples, especially of Russian aggression and the situation in Gaza? Patrycja, you will start.
Well, I think that we need to remember that we have some conventions, some law which is created by the global world, yeah, and we all need to have those states. They have impact on the state of law which we have, and of course I do understand that in some regions some rules could be advanced and at higher level of development. Although I think that some basic principles are common to everyone. And I do remember also, you just referred to those votings in the General Assembly, but for me, one of the most telling moments was that in response to the aggression committed by Russia against Ukraine, one of the powerful voices was taken by representatives of Kenya, who just reminded that, okay, when we gained our independence, we were taught by you that there are some principles of friendly relations and that we cannot change our borders with the use of force. And now, when we accepted it, even if this was not in our interest, you start to violate those principles on which our world lies. So, and this was not only our region which was outcrying, about this aggression, but this was African state with a very strong voice. But I would come back to the comment made by Professor Wasiński. You talked about this self-reflection. Mm-hmm. I think that this is something which is many times missed. And for example, we would like to have the whole world support us in the fight with Russia, but then when, for example, we select delegates to the register of delegates, we neglect candidates from Africa and from Latin America, and we are surprised that those states then are not interested in greater support. And I do also, from our academic world, I do remember what kind of comments were made when there was a new book about the global international law teaching, published by Brill, and 1/3 of the book was devoted to the German international law perspective. Yeah, and then the whole global South was saying, what is this? How you can just present this book as the perspective of the global world when 1/3 of the authors are Germans, and also our region was also missed there. Yeah, that it was completely neglected. There was Europe. It was just West Europe, like Germany and UK, no other representatives. And I think that this is the self-reflection which is missed. Then you pay the price for it. That this book was commented by many scholars that is unacceptable, and even some of the universities, they announced that now they will ask in advance for the full list of the scholars who will be engaged in the project, because they don't want to be in the project which neglect the perspectives of other states. And you were talking about those 141 states which were voting to condemn aggression of Russia. And this is something which also is many times missed by states, that they would like to have a nice resolution in General Assembly, but they forgot that we have 193 states, and majority of them are now in Global South. If you neglect them, you will not have any further resolutions, for example, promoting a special tribunal for aggression. But this, for example, in our case, this reflection just came too late. And that's why, you know, with the eruption of the conflict in Gaza, we lost a little bit a moment, the good moment to promote those good precedents on international level.
Thank you so much. Patryk, your final remarks?
Yeah, so it's an interesting question about the universality of international law and where we stand in 2024 with respect to different states, different people's aspirations for a universal international law, given what is going on in Ukraine and Gaza. Let's not forget, you know, many other places like Sudan, Myanmar, etc. My general sense is, just to wrap up and be brief, is that there are two ways of thinking about this, and we can take a glass half full or a glass half empty approach. And I think a lot of the commentary that I see tends to think of this as a moment of crisis, that, international law is under a lot of stress. States and peoples around the world are questioning whether international law is meeting the demands that we have of it in the 21st century, or, you know, the aspirations that we have at least. But I think, you know, in many ways, if you think about Gaza in particular, the response to the conflict in Gaza, the unprecedented mobilization across different universities on campuses, we see how mobilized students are. This is also an opportunity for international law. I have never seen international law being invoked as much as it is today. It started, I think, in 2022 when there was incredible mobilization to push back against the Russian aggression in at least many parts of the world. And now we have the situation in Gaza, the ongoing conflict there, where people are polarized, no question about it. But what's the response? It seems to be international law. I mean, at least that's what many states are trying to do. They're putting their faith in international law. The question is, of course, what will be the outcome? I think it's too early to tell, but I wouldn't be too pessimistic about this. I wouldn't be too pessimistic. I do think, and this is, you know, here I echo what Patrycja said earlier. It's a moment of crisis, but it's also a moment of opportunity, to use the Chinese expression. And what we need to do in situations like this as international lawyers is to push for respect for international institutions, for international law. And that means that we need to support the International Criminal Court. I do think, you know, we can't speak for the entire world, but as representatives of our region, I do think that it's very important to put pressure on our governments for us to have this conversation and say, look, if the investigation in Gaza proceeds, if there are arrest warrants, the way forward is to let a court of law, an impartial, independent court of law, deal with these matters in accordance with the rule of law. It is not to denounce the ICC as a neo-colonial institution, to question its legitimacy. It is to let the court do its job. And that is the test that I think we need to meet. We need to rise to the occasion, and I think that's our task as international lawyers, to put pressure on our governments here to respect international law. So that's how I would think about it.
Thank you very much. Marek, your final remark?
Yeah. Thank you. I feel that this panel, some parts of this panel, somehow resonates with the previous keynote Professor Period who presented international law as a cultural thing, or at least somehow related to the culture. And so, in other words, international law is a social thing. And if, this is my belief and my conviction, my idea, if international law is to govern effectively, international law must be applied coherently in an unbiased way. So I think that this is one of the most important conclusions from this discussion. And this is also a very important task for international lawyers. We are not only for teaching students, but we are also for talking to the general public about international law and what are conflicts behind legal norms. And my last point is that Tomek referred to the universality of international law, and I would like to stress very strongly that I am against, and this is not my aim, development of Eastern and Central Europe approach to international law. No, this is not my point, although it would be a very dangerous escapism to believe that there are not regional approaches. Let's think about the American position. If we listen to American high-ranked politicians, they are so often talk not about international relations governed by international law, but they talk about rule-based approach to international relations. This is not a Freudian slip. This is this is something that delivers a message how they perceive international relations and rules. My call is that we should, as I stated at the beginning, we should self-reflect who we are being teachers of international law, what is our aim, how are we going to achieve this aim, and this is the most important, how the past weighs on our shoulders. And this is, for me, this is therapeutical, I would say. Thank you.
Thank you so much for this call at the end. Actually, we ran out of time, but since we have started 20 minutes later, so I think that we can take one or two questions, maximum 2 questions from the audience. So please, I encourage you to take this opportunity to ask our great panelists. Dr. Kątkowski, I think that's your reaching towards the microphone.
Thank you very much for this great presentation and great talk in this context. So maybe a little bit comment on what Professor Grzebyk, Dr. Labuda, and Professor Wasiński said about also keeping in mind that we are putting international law kind of in a box that this is something quite meaningless. We are kind of opposing, we are comparing international law on one hand to rules, on the other hand the great powers play. And this is this dilemma which is mostly presented in public. On one hand we have this great politics governed by international relationships, on the other hand there is this international law, and the people tend to accuse international law of not being effective, of not being, not responding effectively to the crises, to the aggressions, to the acts of international crimes, etc., etc. But I'm guessing that a lot of people are forgetting that international law is just a part of much greater play, that we have international system. And international system, we actually measure a lot of different things, like, for instance, power, demographics, economy, etc., etc. And the law is just one of the, let's say, components. We kind of international lawyers center it is a center of the world for us. But in fact, in the context of the international relationships, international politics, this is one of the components of how the global society works. So my question for you is maybe not very related to the law, but we have those three major theories of international relationships. The realism, which is now pretty popular in terms of media, especially the offensive realism, that the great powers have the zones of influence, and there's what we call the Monroe Doctrine. So basically there is a great power, and great power have some areas that consider its own, it's a hegemon, and no one else could somehow intervene. And this let's say, part of the IR is especially, I would say, active in the media zone and other stuff. So basically, the realism, the offensive realism. Then we have this liberal approach, and a lot of people are saying, okay, international law is a product of liberal approach to international law. Other, let's say, schools are not very willing to recognize the value and the importance of to follow rule in international relationship. And we have this third major school we call constructivism, which is the most ambiguous one. But actually, it is, I would say, well, anarchy is what it is. It's basically, I would say, it's a constructivist in a nutshell. So my question is how we could respond maybe to those critics to international law through the prism of international relationships, so through the prism of those three schools. Can we say that, because there is sometimes a lot of people are saying international law is part of the liberal thinking about the international relationship. Is this so? Because I think there is a lot of component, there is a lot of realism component in international law, like for instance consent. Consent is still a center of international law. And there are certain limitations coming because the states are basically required to consent before we could say, okay, there is a rule, there is an obligation, and there is, for instance, international responsibility. So still, I think this is some part of this realist element in international law. So is international law just a product of liberal way of thinking about international relationship, or it's much more ambiguous? Thank you.
Huge question, as always. So let's start with Marek.
Well, thank you very much for the question. And when you have invoked these three ideas, and the problem is with the definition, because, for example, the traditional realism claiming that international law is epiphenomenal, is without any meaning because everything is governed by politics. I think that this type of realism belongs to the past. There are more nuanced versions of realism. And I would say that liberalism and structuralism can also be described as well, kind of realist thinking. But well, if you ask me about my position is a bit of Dworkinian, I would say, because this is well-known metaphor. This is all about argumentation, about making people convinced, right? And in this game, let's say so, a card game, you can use different cards, various cards, with different values. You can use economic argument, moral argument, religious argument, perhaps. And one of these cards is law, is legal argument. I don't claim that legal argument, especially in the field of international law, is stronger. But this is one of the ways how can we argue to convince our audience. So I wouldn't subscribe to the position that, well, international law is epiphenomenal. No, that's not the point, I believe. Well, that's all. Thank you.
Yeah, so it's interesting. I think we're going to maybe disagree here a little bit, but that's good, right? That's why we're here. I think what we see post 2022 is actually a confirmation that, depending on your worldview, you understand events in a different way. So I think 2022 and now Gaza has really revealed to an unprecedented extent, at least for me, how how differently international lawyers think about the world. So for realists, to simplify, post-2022 is confirmation of the fact that international law does not matter. Russia went in, they did what they want to do, they're invading, Israel continues to do what it wants to do, annex territory. International law does not matter. For liberals, like probably myself and maybe Patrycja, you hear me saying, international law to the rescue. We need to have more international law. And if you think about it, isn't that what Ukraine is doing and many states that are invoking international law? That's probably what the liberal perspective is, that we are putting our faith in international law. International law to the rescue, the ICJ, the International Criminal Court. And then the constructivists, which probably Marek has implicitly echoed in his remarks, is that it's all a way of thinking about the world. It's co-constitutive of reality, the language of international law. And I think I subscribe to this also. I don't think of myself as a liberal international lawyer, just to be clear, but I think, the constructivist approach whereby international law co-constitutes reality, and the way we talk about international law has meaning for how we understand international affairs, also resonates deeply with some of the things that we've seen post-2022. So yeah, I guess that's how I would think about it. And the last thing that I will say about this is that I have found the post-2022 experience absolutely incredible in how it has really forced international lawyers to take their masks off. When you see the commentary, but it's not just officially, sort of in official discussions, but also sort of conversations that you have with international lawyers, you really can put people into different baskets depending on how they understand what's going on in the world. And so yeah, to me, it's been an interesting journey because yes, it helps us. The schools of international relations help us to explain why different international lawyers are saying different things about what's going on. Yeah.
Patrycja, you have the privilege to conclude our discussion.
I'm not sure whether I can conclude, but Mateusz, we started with opposing realism with international law. Although I must say that in the classic texts of realists, they do appreciate the role of law, and they just consider law as one of the tools which you can use in the foreign policy. And this is not without the reason that in recent years we observed the development of the research concerning lawfare and the achievement of your of your aims of foreign policy because of the law. For example, as a standard example, the Palestinian people are mentioned. That the Palestinian nation achieved much more because of the legal tools, because of the use of the legal tools, than in result of the use of armed force. Also, for example, US did mention that they observed how effective China or Russia is in the use of international law, of international procedures, which, for example, by those champions of international law from the West were neglected in the past. So I think that I observe a completely different tendency, that the law, which was, for example, considered as a tool to protect weaker part, now is used, as a sometimes tool of oppression. And I see it, for example, in the case of international humanitarian law, which was considered as a law which protects civilians. Now ICL is used, in opposition to human rights law as a tool to justify, for example, total destruction of Gaza. Mateusz. So that's why I think that this approach to law, you can see how sometimes those masks, how the law is abused, how it is presented in different way depending who is talking, and not as the value, but as a really effective tool of foreign policy.
Thank you very much. Previously, Professor Boatyńska talked about coffee break as a basic right of participants of academic conferences. I'm pretty sure that the lunch break is even more universally recognized fundamental right of all of us. So therefore, I would like to close the discussion and make a big applause for our great speakers, Patrycja Grzebyk, Patryk Labuda, and Marek Wasiński. Thank you very much.